March 2026, Visa Bulletin EB-2 India filing dates. Advance. Nearly 1 year. Check your priority date. There is a number sitting in a government database right now. A date. Your priority date. And for hundreds of thousands of Indian-born professionals living in the United States, working in hospitals, engineering firms, research labs, and technology companies, that number has defined the shape of their entire life. It has determined whether they could change jobs, whether they could start a business, whether their spouse could work, whether their children, born on foreign soil, could grow up with them legally. That number has controlled everything. And then the March 2026 Visa Bulletin released. And for EB-2 India, the date for filing. The date that determines whether you can submit your I-485 adjustment of status application. Advanced by nearly 1 full year. 1 year. In a category where movement is sometimes measured in days, sometimes in weeks, a nearly 12-month advancement is not routine. It is a signal. And most people who hear this news make the same mistake. They check the date, they feel relieved, they assume the path forward is automatic. They do not act. They do not prepare. And by the time the April bulletin drops, the window has changed, and they are exactly where they were before. Today, you are going to do something different. For years now, there had been frustration, not from official USCIS statements, not from congressional action, just frustration, building quietly in the EB-2 India community about the pace of movement in the employment-based second preference category. EB-2 India has been one of the most backlogged categories in the entire U.S. immigration system. The backlog exists because of a structural problem in the law. Each country is allocated no more than 7% of the total employment-based green card numbers available each year. That 7% cap applies regardless of how many petitions are filed from a particular country. And India files more employment-based petitions than almost any other country in the world, driven by the massive presence of Indian-born professionals in the H-1B pipeline. The result is a waiting line so long that analysts have estimated it could take decades, in some projections over a century, for a newly filed EB-2 India petition to reach its final destination under current law. The people waiting are not recent arrivals. Many of them have been in the United States for 10, 15, 20 years. They came on F-1 student visas. They transitioned to H-1B work visas. Their employer filed an I-140 petition on their behalf years ago, sometimes over a decade ago, and they have been waiting. Immigration attorneys who monitor the Visa Bulletin every month recognize the indicators of meaningful movement, the gap between the final action date and the date for filing. The inventory numbers embedded in the State Department's monthly cutoff analysis. The pace of demand consumption in EB-2 versus EB-3 across all chargeability countries. The sudden shift in how many numbers are being used in other employment-based categories. When those signals align, the bulletin can move fast. And when EB-2 India moves fast, it matters to hundreds of thousands of people whose lives have been on hold. In the March 2026 bulletin cycle, the State Department's Visa Office released movement that immigration practitioners described as one of the more significant single-month advances in EB-2 India in recent memory. The date for filing for EB-2 India moved forward by approximately 11 months. That is not a typo. 11 months of advancement in a single bulletin cycle. The date for filing, also called the chartability date or the filing date, is different from the final action date. The final action date is the date that must be current before USCIS can actually approve your green card and issue you permanent resident status. The date for filing is an earlier threshold. It is the date that must be current before USCIS will accept your I-485 application for filing. These are two separate gates in the process. And the date for filing advancing nearly a year means that a large group of EB-2 India applicants who previously could not file anything are now in a position to submit their I-485 application. That matters enormously. Because once you file the I-485, your life changes. The response from the immigration attorney community to this bulletin was not quiet. Practitioners who had been advising clients to monitor the bulletin closely began sending urgent communications immediately. The reason is simple, and it connects directly to the window of opportunity that filing the I-485 creates. Once your I-485 is accepted by USCIS, you become eligible to apply for employment authorization on Form I-765 and advance parole on Form I-131. Employment authorization means you are no longer tied to your H-1B employer and your H-1B status in the same rigid way. It gives you what practitioners call work flexibility, the ability to move between jobs, change employers, or accept different positions without the strict constraints of maintaining H-1B status. Advance parole means you can travel internationally while your I-485 is pending without your pending application being considered abandoned. These are not minor benefits. For someone who has been locked into a single employer for years because of the green card process, the I-765 EAD card represents a meaningful shift in their professional freedom. And for families who have been afraid to travel because of status complications, advance parole restores a basic element of normal life. But all of this begins with one step: filing the I-485 while the date for filing is current. Let me be precise about what date for filing means in practice, because this is where confusion costs people. USCIS uses two charts in the Visa Bulletin each month, Chart A and Chart B. Chart A is the final action dates chart. This shows the dates that must be current before USCIS can approve a green card. Chart B is the dates for filing chart. This shows the earlier dates that determine whether USCIS will accept an I-485 for filing. But here is the critical detail. USCIS does not automatically use Chart B. Each month, USCIS publishes a separate announcement, typically at the beginning of the month, confirming whether it will accept I-485 applications based on Chart B for that month. If USCIS confirms Chart B is accepted, you can file using the date for filing. If USCIS only accepts Chart A, then you must wait for the final action date to be current before filing. For March 2026, USCIS has confirmed acceptance of Chart B for employment-based categories. That confirmation is what opens the door. That confirmation is what makes the nearly one-year advancement in the EB-2 India date for filing actionable right now. Check uscis.gov directly. Confirm the current month's filing instructions. Do not rely on what a friend told you or what a forum post said. The official USCIS confirmation is the only thing that counts. Now let's talk about who specifically is affected by this movement. If your priority date, the date on your I-140 approval notice, or the date your labor certification was filed if your case went through PERM, is earlier than the new date for filing cutoff for EB-2 India in the March 2026 bulletin, you may now be eligible to file. Pull out your I-140 approval notice right now. Find the priority date on that document. Then look at the March 2026 Visa Bulletin, specifically Table B, employment-based categories, the row for India, and the column for EB-2. If your priority date is before that cutoff date, you are in a position to act. If your priority date is after that cutoff, the window has not reached you yet. But even if you cannot file today, an advancement of this magnitude brings millions of cases closer, and understanding where you stand is the first step. There is a separate issue that deserves direct attention: the difference between EB-2 and EB-3 for India, and why some people have been strategically downgrading their petition. In previous years, EB-3 India occasionally moved faster than EB-2 India because of how numbers were allocated across categories. Some applicants chose to voluntarily downgrade their I-140 from EB-2 to EB-3 to take advantage of faster movement in EB-3. If you downgraded and are now watching EB-2 advance rapidly, you may be wondering whether upgrading back makes sense. This is a highly case-specific analysis. Upgrading back to EB-2 requires a new I-140 in the EB-2 category. Whether you can port your original priority date depends on the specifics of your case, your employer's cooperation, and the underlying labor certification. This is not a decision to make based on a YouTube video alone. This is a decision to walk through carefully with an experienced immigration attorney who understands your case history. Let's also address the EB-2 National Interest Waiver, the NIW, because it is directly relevant here. The NIW is a pathway under EB-2 that does not require employer sponsorship or a labor certification. Researchers, scientists, physicians, advanced degree professionals, and others who can demonstrate their work is in the national interest of the United States can self-petition through the NIW. If you filed a self-petitioned EB-2 NIW I-140 and your priority date now falls within the current date for filing range for EB-2 India, you have the same opportunity to file an I-485. The NIW pathway has become increasingly popular precisely because it removes the dependency on an employer. For professionals who have been locked into employer-sponsored cases for years, an approved NIW I-140 represents independence in the green card process. If you have an approved NIW and your priority date is current under Chart B, move. There is something else the EB-2 India community needs to understand about what happens after you file the I-485. The I-485 is not the finish line. It is the starting gate for the final phase. After filing, USCIS will schedule a biometrics appointment. They will conduct background and security checks. They may, and in most employment-based cases will, schedule an interview at a local USCIS field office, though some cases are approved without interview. The I-485 process can take additional months or years depending on the field office, the complexity of the case, and whether any issues arise during adjudication. But here is the critical point. You cannot be approved if you have not filed, and you cannot file if you are not prepared. Preparation means gathering all required supporting documents, your I-140 approval notice, your passport and travel history, your I-94 records, civil documents, tax records in some cases, the I-693 medical examination completed by a USCIS civil surgeon, and photographs. It means confirming your current immigration status and ensuring there are no gaps or violations in your record. It means reviewing whether any prior issues, travel, status violations, prior removals, misrepresentations need to be addressed before or during the filing. And it means working with an attorney who can review your specific case before you submit anything. One more issue that is specific to families in the EB-2 India pipeline, the dependent beneficiaries. When a principal applicant files an I-485 under EB-2, their spouse and unmarried children under 21 can file as derivative beneficiaries on the same case. That means the spouse's employment authorization, the children's status, all of it can move forward together with the principal I-485. But the children issue carries the same aging out risk I mentioned before. Under the Child Status Protection Act, certain protections exist to prevent children from aging out of derivative beneficiary status during the process. But CSPA calculations are specific and technical. If you have a child approaching 21 who is listed as a derivative beneficiary on your EB-2 case, get a CSPA calculation done immediately. The movement in the March 2026 bulletin may be exactly the window you needed, but for an aging child, waiting even 60 days could change the outcome. As the spring bulletin cycle continues, more clarity will emerge about whether this advancement holds, whether USCIS continues to accept Chart B filings, and how quickly the demand in the newly eligible priority date range is processed. The April 2026 bulletin will tell the next part of the story. It may continue advancing. It may hold steady. It may retrogress. What the March 2026 bulletin tells us right now is that EB-2 India moved nearly 1 year in a single month. That is real. That is documented. And if your priority date falls within that newly opened range, the window is open today. Knowing this right now does not make you a target. It makes you prepared. It means you understand your own case. It means you are protecting your career, your family, and your future. Find your priority date tonight. Check the March 2026 Visa Bulletin. Call an immigration attorney this week. Do not wait for someone to tell you the window closed. Share this video with every Indian-born professional you know who is stuck in the EB-2 or EB-3 backlog. They may have been waiting years for this moment. This video might be exactly what changes their next step. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.